The incident occurred on 19th December the year 2000. Thereafter, the authorities took action, especially the military police who arrested the army personnel who were involved, and several of them were identified at an identification parade held in the Magistrates Court of Chawakacheri. Thereafter, in 2002, the Attorney General requested the Chief Justice to appoint a trial at bar to try the accused. And several witnesses were called, and chief among them was Maheswaran, who was eyewitness. However, the trial proceedings had its hiccups. Judges were transferred, and in fact, one judge, Mr. Saratambe Pitya, was assassinated during the course, and there was a lot of delays. And in one instance, the court ruled that the statements given by the accused, that is the confessions given by the accused to the military police, was admissible. Then thereafter the defense appealed to the Court of Appeal, and thereafter the Court of Appeal ruled that the statements given to military police is not admissible. And then the trial proceeded, and out of the 5 accused, 4 were acquitted for lack of evidence, and one of them, Corporal Sunil Ratnayaka, was convicted, and he was sentenced to death. He appealed to the Court of Appeal, which affirmed the sentence, and again in an appeal to the Supreme Court also affirmed the order given by the trial at bar. Things were as it is, and I think about 15 or some years had passed, and the tragic thing was that the people who survived, their families, were left without any compensation. Also, although the state was responsible for the deaths, then President Gotabaya Rajapaksa granted a presidential pardon to the chief perpetrator. Then the aspect of rule of law in this country was put to question, and that act of granting a pardon to this confirmed criminal was never justified. Actually, there is a procedure, even though the president has power to grant free pardon to persons in terms of the Constitution, there has to be certain norms that have to be followed. First thing, we have the president has to call for a report from the Chief Justice, the Attorney General, and also the judge who had convicted the person. And those reports have to be considered, and I'm sure all those functionaries had been wise enough to recommend not to grant pardon. So against that background, still the president had persisted in giving the pardon.
දෙසැම්බර් 19 වෙනිදා මේ 2008 දෙනෙක් තාත්තලා 3 දෙනයි ඒගොල්ලන්ගේ දරුවෝ 3 දෙනෙක් එක්කෙනෙක් අවුරුදු 5යි, එක්කෙනෙක් අවුරුදු 11යි, එක්කෙනෙක් අවුරුදු 13යි. අම්මලා දෙන්නේ මේ ප්‍රදේශයට ගියා ඒගොල්ලන්ගේ වත්තේ තියෙන දර ටික අහුලාගෙන පොල්ලතු ටික අහුලාගෙන එන්න. මේ අවස්ථාවේදී සෙබළු දෙන්නෙක් ඇවිල්ලා තියෙනවා පෙට්‍රෝල් එකක් ඒ පැත්තට. එතන ඉඳලා තියෙන එක්කෙනෙක් තමයි සුනිල් රත්නායක. ඒතර ඒගොල්ලෝ මේගොල්ලෝ අල්ලගෙන තියෙනවා. එතන තව පුද්ගලෙක් ඉඳලා තියෙනවා එයා මරණයටපත් වුණේ නැහැ මහේශ්වරන් කියලා. මේගොල්ලෝ එක සෙබළෙක් එතන තියලා මේගොල්ලෝ බලා ගන්න රත්නායක ගියා තව සෙබළු 6 දෙනෙක් එක්ක ඇවිල්ලා මේගොල්ලෝ එකතු වෙලා මේ කට්ටියට ඔක්කොම පහර දෙන්න පටන් අරන් තියෙනවා. මහේශ්වරන්ට සීයේ නැති වුණාම මහේශ්වරන් කම්බියටකට උඩින් වීසි කරලා මේගොල්ලෝ අනික් කට්ටිය අරන් පැත්තකට ගිහිල්ලා තියෙනවා. ඒගොල්ලෝ හිතුවා මහේශ්වරන් මැරුණා කියලා. මහේශ්වරන් මැරුණා කියක අනික් කට්ටිය දැක්කා කියලා හිතාගෙන සුනිල් රත්නායක ඇතුළු මේ පිරිස එතන හිටපු ඔක්කොම එතකොට 8 දෙනෙක් මේ කට්ටියට පහර දීලා සීයේ නැති වුණාන් පස්සේ මේගොල්ලොන්ගේ බෙලි කපලා වලලලා තියෙනවා. පස්සේ මහේශ්වරන්ට සීය ඇවිල්ලා දුවගෙන ගිහිල්ලා රතුකුරුස සංවිධානයේ පොලිසිය ළඟම තිබුණ හමුදා කඳවුරේ පිරිසකුත් එක්ක ආපහු ඇවිල්ලා තියෙනවා. එනකොට මහේශ්වරන් අනුරෝගයේ තියෙනවා එතන ඉඳලා සුනිල් රත්නායකත් මේ කරපු දේ හිටියා කියලා. සුනිල් රත්නායකගේ ප්‍රකාශ අනුව එළි වෙලා තියෙනවා සුනිල් රත්නායක ඇතුළේ මේ පිරිස මේගොල්ලන්ට පහර දුන්නා. සීයේ නැති වුණාම ඊටාම දාමරික අන්දමට මට විශ්වාස කරන්න බෑ සෙබලෙක් කොහොමද මෙහෙම වැඩ කරේ කියලා. ඊට පස්සේ මේ කට්ටියගේ බෙල්ලේ දෙපැත්තේ නහර තියෙන මොලේට ලේ යන මොලෙන් එන මේ නහර කපලා තියෙනවා පීයක් අරගෙන. ඒ නහර කපලා මේ කට්ටිය ඔක්කොම වලලලා තියෙනවා. ඒතොර මහේශ්වරන්ගේ ප්‍රකාශ අනුව හරියන් ප්‍රශ්න කළා සුනිල් රත්නායකගේ තැන් වලට ගිහිල්ලා මලමිනි පෙන්නලා තියෙනවා. එතකොට මේ පුද්ගලයා මේ දරුණු අපරාධ උතුරේ වෙන්න පුළුවන් නැගෙනහිර වෙන්න පුළුවන් දකුණේ වෙන්න පුළුවන් මොනම පවුලකට හරි කරා නම් තමුන්නාසෙලා මේක අනුමත තමුන්නාසෙ නැගිටලා මාරු වෙනවා මේක අහන් ඉන්න බැරි හින්දා තමුන්නාසෙලා මේ අනුමත කරනවද මේවා දරුණු අපරාධ මෙවැනි අපරාධයක් කරපු කෙනෙක් නිදහස් කරා කියලා තමුන්නාසෙලාට කොඩියක් දා ගන්න බෑ අපි රණවිරුව නිදහස් කරනවා කියලා ඝාතකයා මෑයි.
So the Mirusuvil Massacre case is an emblematic case in that it has seen justice being delayed, and this is mostly because at the present moment the person who was convicted for the massacre was pardoned in 2020 by the then President Gotabaya Rajapaksa. This is in a context when there was a trial and the Supreme Court affirmed the conviction. So the case went through all those steps in terms of a criminal justice trial and an appeal. And the highest court of the land found that the conviction stood. Despite all of that, the president used his power of a pardon to release the convict in this case and provide a presidential pardon. Now this is the latest in a series of setbacks in terms of getting justice in Sri Lanka. And the power of the pardon, while the president has that power, it needs to be also critiqued in terms of how the power is used. So when the pardon was given in 2020, many of us were outraged. There was a whole series of comments, criticism in terms of how the pardon was used. And the criticism came largely from the fact that this particular case went through the criminal justice system. And there was no clear evidence that there was some arbitrary decision, steps taken to prevent justice from taking place. So when the pardon was given, there was discussion with the victims, with the affected communities, and there were several fundamental rights petitions filed in the Supreme Court challenging the pardon. This was in 2020. So several victims and interested parties filed cases, and most recently the Supreme Court recognized there was a matter to go into in these pardon matters and gave leave to proceed. So the highest court of the land has recognized, while the president has the power to pardon, that the pardon also needs to be used carefully, needs to be used in the most rarest of cases when there has been an injustice in the criminal justice process. So now the matters are before Supreme Court. We will have to see how the next steps proceed. But the issue is, and I think it's very important to recognize, that victims face continuous setbacks and challenges in obtaining justice in Sri Lanka. And this is from delays in justice, delays in cases, evidence tampering, and a whole host of things that has been documented. And the most recent use of the pardon to release a convict is also another setback in obtaining justice. So I think we need to really look at the power of the pardon. The Mirusuvil Massacre case captures many elements in terms of the setbacks in justice, but it was also one of those cases where victims could celebrate the fact that after several years, after several setbacks, they were able to obtain justice, but only for a few months. So this case captures many dimensions, but I think the power of the pardon and how the pardon is used and abused is also something we need to look into. So the next steps in terms of the Supreme Court hearing, we will have to watch very carefully, but I think it's a matter that we all need to be aware of because it is of public interest nature and it can affect any individual.